Good morning, everyone. Today, I would like to speak on an important aspect of criminal jurisprudence, quashing of FIR, a vital safeguard against abuse of the criminal justice system. An FIR, or First Information Report, is the foundation of criminal investigation. It sets the criminal law into motion. However, there are situations where an FIR is filed maliciously, without proper evidence, or purely to harass an individual. To prevent misuse of legal process, the law provides a remedy. The power of the High Court to quash an FIR. Under Section 482 of the Criminal Procedure Code, 1973, now reflected in Section 528 of the Bharatiya Nagarik Suraksha Sanhita, BNSS, the High Court has inherent powers to prevent abuse of process of law and to secure the ends of justice. The landmark judgment in State of Haryana v. Bhajan Lal laid down the guiding principles for quashing of FIR. The Honorable Supreme Court enumerated categories where the High Court may exercise its inherent powers. These include 1. Where allegations in the FIR do not disclose any cognizable offense. 2. Where the allegations are absurd or inherently improbable. 3. Where there is an express legal bar to institution of proceedings. 4. Where the proceeding is manifestly attended with malified intention. This judgment remains the backbone of jurisprudence on quashing. Another important decision is John Singh v. State of Punjab, where the Supreme Court clarified that even in non-compoundable offences, the High Court can quash proceedings if parties have settled the matter, provided the offence is private in nature and does not affect society at large. Similarly, in Narinder Singh v. State of Punjab, the court laid down factors to consider while quashing criminal proceedings based on compromise, such as the nature of offense, stage of proceedings, and impact on society.
It is important to understand that quashing of FIR is an extraordinary power. The High Court does not conduct a mini-trial. It only examines whether prima facie an offense is made out. If the complaint discloses essential ingredients of an offense, generally, the court will not interfere. The Supreme Court in Niharika Infrastructure Private Limited v. State of Maharashtra emphasized that quashing at the investigation stage should be done sparingly. The court held that investigation should not be stifled unless the case falls clearly within the parameters laid down in Bhajan Lal. Now, let us understand common grounds on which FIR is quashed. Purely civil disputes given criminal color. Matrimonial disputes settled between parties. Commercial transactions where dispute is contractual. Cases filed as counterblast or for harassment. However, serious offenses like murder, rape, dacoity, corruption, or offenses against society generally cannot be quashed merely on settlement. The object of quashing power is twofold. 1. To prevent abuse of process of court. 2. To secure the ends of justice. This power balances two competing interests: the right of the individual against wrongful prosecution and the duty of the state to investigate crimes. In conclusion, quashing of FIR is not a routine remedy but an exceptional relief. It acts as a constitutional safety valve in criminal law. While courts must protect individuals from malicious prosecution, they must also ensure that genuine criminal cases proceed without obstruction. Therefore, the inherent power of the High Court is to be exercised with caution, sparingly, and in rarest of rare cases, guided by judicial principles and not personal discretion. Thank you.